All right, we are going live here in just a second. Alrighty, folks, looks like we are live. I'm here with my friend John Skiba, the Consumer Warrior. Very glad to have you on here, John. Can you go ahead and introduce yourself a little bit?
Yeah, George, glad to be here again. Look forward to every time we do this, interacting with your audience. I'm John Skiba. I'm a bankruptcy and consumer attorney in the state of Arizona. I also founded the Consumer Warrior YouTube channel, which is how I think George and I got connected. And so glad to be here. I help consumers with all these types of things, debt collection, lawsuits. I always joke all the horrible stuff out there, trying to bring some sense to it and some organization and hopefully some peace of mind that there are ways to deal with these issues and move on with life. So glad to be here today.
Fantastic. Thanks for coming on the show. All right, folks, we are talking about today how to get a debt lawsuit dismissed. All right, so we're going to go over some of the basics on getting your debt lawsuit dismissed today. We also reserve quite a bit of time for any questions that you all have. So if you have a question, go ahead and put it into the chat now. As you can see, the chat fills up pretty quickly even before the webinar starts. So get your questions in there now. Please, let us know what state you're in. Give us a pretty detailed situation on your case. Let us know what happened. What's like the last action that occurred on the case, who the case is with, things like that, and also, those are kind of like the main ideas. Like what happened last, who's the case with, what's it for. Put those things into your question in the chat. That'll be helpful and allow us to give you a better, some better answers. All right, and as we're getting into this, quick disclaimer: we are not your lawyers. I'm not a licensed attorney. John is a licensed attorney in Arizona, but he's not your lawyer either. We aren't providing legal advice here. We're just doing a webinar. We aren't creating attorney-client privilege here either. All right, so those are some things I say because of regulations in the space already. Also, happy Pioneer Day to everybody here in Utah, where I'm based. July 24th is Pioneer Day, celebrating the great pioneers arriving in the state of Utah. And there you go. So, celebrating that. All right, John, we got a question for you.
Let's do it.
Yep, great. On how to get a lawsuit dismissed. So, what can you say to a judge to win a debt collection lawsuit?
Ooh, that's the question of questions. As far as a lot of it depends on where the case is at. I always joke that the wheels of justice move very slowly on civil cases, and so it's rarely something that happens with just one filing or something like that. The number one thing we can do, which we talk a lot about here, is filing the answer. It's difficult to win the cases quickly. It's easy to lose the case quickly, and that the first thing is by not filing the answer. If you don't file that initial answer with the court after you get served with the complaint and summons, a default judgment is going to be entered, and then you're done. And it's much more difficult even to settle at that point, and it just makes life difficult. So, as far as presenting information, I break it down into two groups. I look at a collection lawsuit brought by an original creditor, like American Express, Capital One, or one brought by a junk debt buyer, Portfolio Recovery, Midland Funding, LVNB, those types of companies. The cases with the original creditor lawsuit, I was just talking to a guy about this in my practice recently. If it's original creditor, if it's actually the company that you signed up with, unless you have a defense like identity theft or something like that, I usually recommend trying to settle the case or pushing it into private arbitration. We've talked before about filing a motion to compel private arbitration. Those are some good strategies to get the case resolved. If it's a junk debt buyer, those cases, there's a lot more moving parts to it. They have to prove not only that you had the original account, but that they transferred it to this new entity. And so there may be some stronger defenses there. So it can be very fact specific as far as, how you go about that. And also, I tell people you need to define what winning is for you. A lot of times just settling the case, if they're suing you for 10 grand, you get the thing settled for $2,500. That's a win. Nobody likes to pay anything, but if you're, paying $2,500 instead of $10,000, that can be a win as well. And so sometimes just changing that from, hey, I'm going to win at all costs and take this to trial, a lot of times that's not a good option. And settlement or arbitration or something like that's going to be a better end result for you overall.
Okay, great. So is there a magic bullet? Is there a magic line that you can say this sentence and get the case dismissed?
I wish there was, because my job would be a lot easier and I'd have a lot more free time. But unfortunately, usually there's not. And it's, the way I look at it was, particularly when I'm litigating a case and defending something, I go through every line, every bill of sale, every monthly statement. I make sure that I know all the specifics and the details, because sometimes you will find things in there that make it much more easy, but there's not going to be something where you're just going to be able to say, hey, judge, what about this? And the case is going to go away. And something a lot of people think is if they come in and say, look, I'm unemployed, judge, or I have a medical issue or a hardship. Judges are more like umpires. While that may impact settlement, they're not. The judges are just there to tell you whether whether you're liable or not whether you have the ability to pay a judgment in the event that one is entered. So that's something to think about as well.
Right. I think umpire is good, even better than a referee. Right. Umpire is a little bit more standoffish than a referee, even, I think.
Yeah.
Great. One thought that comes to my mind is, if the consumer wants to get the case dismissed, one thing they can say is, please dismiss the case. Right? I think if you want to get the case dismissed, it's helpful to ask for the case to be dismissed. Is that right?
Well, to your point with the umpire not being involved, the court's not going to tell you how to prosecute your case.
Right.
And often, if you don't object, like if the creditor asks for something and you don't object to it, sometimes the court will just give it to them. You can file a motion to dismiss. If you feel that there's a legal basis for your lawsuit to be dismissed, you can file it. And if the other side doesn't respond to it for whatever reason, the court may just grant it. I know here in Arizona where I practice, the rules of civil procedure specifically state that a party not responding to a motion can be deemed as consent for whatever they're requesting for to be granted. And so if you feel that there's a basis for the case to be dismissed, whether they served you inappropriately, whether there's not jurisdiction of the court, whether you're trying to compel private arbitration, which I know you can, on SoloSuit, you guys have a product that can help with that. Go ahead and file it. And if they don't respond to it, the court may grant it just because, they'll interpret their silence as consent for it.
Right. Great. Yes. So if you want to get the case dismissed, at the very least, right, there's not a magic bullet like that you can say to get the case dismissed, but you should ask for the case to be dismissed. Right. And what's like the rationale? So it's like a motion to dismiss for lack of prosecution. Is that kind of the most common one that you would suggest, or is it motion to dismiss for something else?
Yeah, I mean, usually the motion to dismiss, when I'm filing them, it's often because we've actually filed an answer, we're litigating the case, and then for whatever reason, it's just the case is sat dormant. The creditor hasn't done anything with it. Nationally, the last statistics I saw show that over 95% of consumers that get sued do not file an answer, and it ends up in default. So with these law firms, that's what they're used to. They're used to processing default judgments and then trying to garnish wages or bank accounts. When you file an answer, you're part of the 5%. And so it's a little bit different. And so people are surprised. I'm surprised sometimes where this, even a large lawsuit, we'll file a response to it and then we just don't, it's silence. I've had cases where it's silence for a year and we'll go ahead and file a motion to dismiss for failure to prosecute the case. The court will usually grant those. If they file the lawsuit, then they just don't do anything. They don't do any discovery. They don't file a motion for summary judgment. It may be something you get dismissed for something like that. I also will file motions to dismiss if they serve you in the wrong area. Sometimes they'll serve you, I know you're in Utah, Georgia. If someone lives in Salt Lake, but they're serving you in a court out of Provo or something like that, there may not be, the venue may be incorrect, and you can file a motion to dismiss if they're, not in the correct court. So there are things like that that you can look at, where they served you, if they filed an answer and they're not pursuing it, or the big one that we talk about a lot, if you want to push it into private arbitration, because that's in your credit card agreement that allows you, you can file a motion to dismiss, compel private arbitration as well.
Nice. Fantastic. Okay, let's take a look at another question here. What happens if you lose a debt collection lawsuit?
If you lose, if you go to trial and lose, then a judgment can be entered against you. And so if a judgment, the reason why you don't want a judgment is because, these credit card companies, they're loud, they're annoying, they can affect your credit. But at the end of the day, without that judgment, they can't do a whole lot. They can't take anything from you. But if you lose and they get a judgment, if your state allows it, they can do wage garnishment. In Arizona, they can take 10% of your wages. I know there are a couple states that don't allow it. I don't think Texas allows wage garnishment, which always is interesting to me. But like bank levy, they go after money in your bank. They can record it, and it can act as a lien against real estate that you own in that particular county. So once they have a judgment, it can be rough. And not only that, in most jurisdictions, the judgments are good for a set period of time, and then they can be renewed. Like in Arizona, they're good for 10 years. They can be renewed every 10 years for the rest of your life. And interest continues to accrue and accumulate. So once they have a judgment, it's still worth your time reaching out, trying to settle it and get it resolved. Just ignoring it, all of a sudden a wage garnishment's going to pop up or something out of the blue and cause you some problems down the road.
One of the things fascinating in Texas is that, wage garnishment's not allowed, but collectors still sue plenty frequently in Texas. As they have other methods of collecting even besides the wage garnishment.
Yeah, no, and it could be, I don't know Texas. I know Florida has an unlimited homestead exemption. I think Texas does as well, or they have a really high one. I always wonder how debt collectors collect in Texas.
Right.
It doesn't go with the reputation of the state either that they wouldn't allow wage garnishment, but kind of a interesting state by state how they treat things.
It is interesting. It is. Great. All right, let's get into questions from the audience. We got a question from Pere. I take portfolio recovery to arbitration for $2,400 with a PayPal debt. They don't want to settle for less. They asked $1,900. What should I expect in arbitration?
So if you're in private arbitration, particularly, I usually go through AAA, through the American Arbitration Association. Once you initiate it, which is really simple to do on their website, it walks you through it, and then you can even call them and they'll help you to go through the initial process. Then they will assign an arbitrator to the case, which is just kind of a private judge. They're typically attorneys, and they will set up an arbitration hearing, which is like an informal trial. I know here in Arizona right now, the ones that I've done recently, they've all been done via Zoom. You have the option of appearing in person. I believe they charge more. They're particularly going to charge the creditor more. But as far as the arbitration hearing, it's fairly informal. Essentially, it's similar to like a small claims type trial where they'll allow each side to put on evidence. The rules of evidence are really, really non-existent. They'll accept most things into evidence, and then the arbitrator will try to review it and determine, where it's all at. So, and then they'll issue an arbitration award, either for you or for the creditor. If the creditor wants to collect on the arbitration award, the award in and of itself is not something that they can just take and garnish your wages with. They actually have to file that with the court and get the court to, essentially sanction that before they can move forward with it. So that's generally what the process is. In my experience, it's rare when the creditor will push it to an actual arbitration hearing, particularly for a debt like that that's $2,400. The creditor is going to end up paying a filing fee that exceeds that if they actually assign an arbitrator to it, because you have to pay the arbitrators. It's a private company. But that's typically what you can expect if it actually does go forward.
Okay, great. Question from Raquel. I was notified of a suit through a notice stuck through my door. Is this illegal?
It depends. It depends on, the rules of your particular state. I know that in a lot of, like in Arizona, again, where I practice, personal service is the default, where they actually have to come to you, put it in your hand and say, you've been served. However, if they can't catch you at home, or if they try multiple times and they can't find you, or they feel like you're dodging service, in Arizona, they can go get what's called an alternative service order. and the court will give them permission to mail it to your last known address and come and tape it to your door. So you may want to call the clerk of the court, see what's been filed. Usually they do require that they include a copy of that alternative service order so that you can see that it was actually service. But I always say to err on the side of just thinking it's legit. I'm not a proponent of dodging service. I know there's people all over YouTube and the internet, and they always yell at me when I say this. The people that try to avoid service, they're the ones that end up surprised with a wage garnishment 6 months down the road. I always say it's better to deal with it head on, either settle it, fight it, file bankruptcy on it, whatever you're going to do, but just get it dealt with rather than having this unknown thing out there. So if they've taped that, I would assume that it's legitimate, and you ought to maybe contact the court where it says, and they'll let you know if there's an alternative service order that allows them to do that.
Right. And even if it was served improperly, the person can still lose the lawsuit if they don't respond. Right?
Yeah.
Yep. So you can use, Raquel, you can use SoloSuit to respond. You can just click the button alleging improper service as an affirmative defense, and that'll protect your rights. And then if you do prove that it was served improperly, that might lead to like a dismissal of the case, and then they might sue you again and just make sure they serve you properly, or they might just let it drop. Who knows? All right, question from Andrew. After being served by Midland Credit Management, I disputed everything. Once I did that, the judge ordered us to mediation, and Midland sent me an offer letter to settle. Is any of this good news?
Well, I always say, any settlement offer is good, because, and I tell my clients this: if they're suing you for $10,000 and they send a settlement proposal and saying they'll take it $6,000, I always say, just because we ask, we just say $4,000. So it's kind of going back to that defining what a win is. The fact that you filed the answer, you've avoided the default, they're engaging in settlement discussions. Midland, in an FTC filing, it said Midland pays on average 4 cents on the dollar for their debt. And so you got to look, they don't have that much skin in the game here. And so if you can keep pushing that, maybe provide some hardship as far as why they should take a lower settlement. I don't usually recommend actually providing financial information like bank statements and tax returns and all that kind of stuff. But, letting them know if there's a hardship, if you're on Social Security, if there's something like that, as far as why they should take a lower amount, I think it's a positive thing. So, yeah, I think that's absolutely a positive approach that person's taking.
Yeah. Sounds like something to celebrate to me. Right?
Yeah.
It sounds like basically you're getting the case settled, Andrew, which sounds like a win. The degree of the win is based on how much the settlement offer is for.
Yeah.
Right? Yeah. Great. Question from Shelby. Filed an answer, and they sent me interrogatories. If I want to settle, do I settle with the attorney or the company? And do I have to answer them if I decide to settle?
Yeah, good question. And, I get that question a lot too, is, hey, if I want to settle, do I still need to file an answer? You should always plan on responding, to whatever it is that they're sending you. If you're trying to settle this, fine, you can work that out. Interrogatories, written discovery, like interrogatories, requests for admissions, requests for production, they're the bane of every lawyer's existence. It's so tedious, and they ask you all these questions, you don't want to do it. If you can get it settled before they're due, then I would say don't worry about it, and make sure that it's in writing and that everything's squared away that way. But like requests for admissions, if you don't respond to those timely, they're deemed admitted in most jurisdictions. So you need to be really careful with what is it they're sending you. And until you have the settlement agreement in writing, the parties are on the same page, and usually the creditor has filed a notice of settlement with the court, you need to continue to operate as if there is no settlement at that point, and respond to everything that they've sent over.
Great. Okay. Question from Gina. I was also served with a document stuck in my front door handle. Another person just stuck on the door. Usually the documents are going to be taped on the door, right? Isn't that like the standard practice?
Yeah, I always hear that they are, but then the wind blows them off and they're in the bushes or something next to the door. So, right. But that's typically what they do is they'll right. tape it and then also mail a copy.
They used to nail the documents to the door, right? Back when people had
a wood door.
Yeah, more less fragile doors.
Yeah.
Yep, and then no envelope or anything, papers open for anyone to see, no privacy at all. Is this okay?
Yeah. I mean, I don't think that there is. I mean, because the question is, what's if we're not okay with it? Which obviously it can be embarrassing, and the whole if it's in public information out there, there's probably not any like FDCPA liability for something like that. Not only that, the court, like I said, usually if they're doing that, there is an order from the court that tells the process server exactly what they need to do, and usually it just says post a copy of the summons of complaint and then mail it. So yeah, unfortunately it stinks, but my guess is that the court order tells them they can do that, and there wouldn't be any issues or liability, at least as far as the court's concerned, for them doing that.
Right. My understanding here is that the FDCPA prohibits usage of things like a postcard to collect on a debt pre-litigation, but once litigation begins, the lawsuit's public, so it doesn't really matter if the legal documents are in an envelope or not.
Yeah, I'd agree.
Question from M. Midland filed against me, but may be past the statute of limitations. I need clarification on this. So I guess he's being sued, but he thinks it's past the statute of limitations. So pretty much, what does he do?
Yeah, I mean, I mean, that's a place where a motion to dismiss could come into play. If they serve you the complaint and summons, you think it's outside the limitations period, you could file a motion to dismiss, stating that it's outside the statute of limitations, and then they would have to come in and provide information showing that it's not. First of all, you need to figure out what it is. It varies from state to state as far as what the limitations period is. And then you need to look and see when did it start running? When did it start? And typically it's when one party can sue another. And so I always interpret that to be, because if you look at the terms and conditions of a credit card, once you hit 30 days plus past due, technically you're in default and they could sue you. They don't, they'll usually do internal collections for 6 months and then charge it off. But the creditor will often try to use the charge-off date as when the statute starts to run. I have successfully argued that it's actually when the account is just 31 days late, because then you are technically in default at that point. And so sometimes it's just a matter of months like that. And so find out when your limitations period is. Is it 3 years, 4 years, 6 years, whatever it is? Go back and look and see when was the last payment made, and then look out probably 30 to 60 days beyond that. And that's when that time period starts to run. And it goes right up until they actually file the lawsuit. And if it's outside the statute, you can file a motion to dismiss instead of an answer. Even if it's denied, the court will then give you an opportunity to file an answer. Or even if you already filed an answer, you can file a motion to dismiss or motion for summary judgment after the fact, showing that the statute of limitations is run.
Okay, fantastic. Question from John, another John. Citibank served me with an arbitration hearing for December in PA. I answered their summons. Can I get this dismissed? Citibank didn't sell the credit card debt of $16,000. The debt is 1 year old.
So Citibank requested arbitration on it? Was that the question?
Yeah, he says Citibank served me with an arbitration hearing for December. Sounds a little bit abnormal, but
yeah,
there it is.
Yeah, I mean that would be at least in the states that I'm aware of. As far as because the creditors typically it's always funny, they have the arbitration clause, but they don't want to do arbitration. It's more of it's an approach to help them avoid class actions. Is why clauses are there.
In the next part of his question, he says, "I answered their summons." So maybe he's a little bit confused on arbitration versus litigation.
Okay. So, and I'm sorry, what was the final question then on it?
He is asking. Let's see here. Can I get this dismissed?
Yeah, I mean, it's going to depend on the facts, kind of like what we were talking about, was whether there's statute of limitations. I give everybody 3 approaches. You can fight it, settle it, file bankruptcy on it. Those are really your 3 options when it comes to debt collection lawsuits. If you're going to fight it and prevail on it, you're going to have to show either, like a Citibank, if they didn't sell the debt, if there's not an identity theft defense, it's going to be tough. It's an uphill battle. I usually recommend looking at settlement options at that point and trying to put yourself in a position to get the best settlement possible, which includes providing them information if there's hardship that you're going through, if you're unemployed, Social Security, medical issues. again, without providing all your financial information to them, or trying to push it into private arbitration. And that's what I know Solo Suit has the ability to, they have some products that can help you to get that into private arbitration. That's usually your best bet when it comes to accounts like that. That's going to put you in a better position to negotiate. I always say if you're going to file that, you got to do it in good faith. You got to be ready to go forward with the arbitration process. But that procedural transfer of the case from court to arbitration can help you get a better settlement, and maybe get a resolve for a lower dollar amount.
Fantastic. XRXR asks, what motions are available to dismiss a case? Person who served was impersonating a police officer and banging aggressively at my residence. That sounds pretty intense.
Yeah, you know what though, and somebody can correct me if I'm wrong. I do enough FDCPA work, which is the Fair Debt Collection Practices Act, to be dangerous. But I don't believe the FDCPA applies to process servers. I think they're one of the unique carve-outs, which is kind of interesting because they're really that's where the rubber meets the road. They're the ones knocking on your door kind of thing. So, because normally impersonating someone that they're not, that could run into FDCPA issues. But with the process server, I don't believe that it applies to them. So as far as getting it dismissed, again, it's very fact specific for each case. Sufficiency of evidence. Do they have enough evidence in the case? Statute of limitations. Those are the kinds of things you have to kind of do a deep dive into, and it can get a little bit complicated. And that's why, filing the answer using Solo Suit, at least get the answer filed. Sometimes, you do need to go talk to an attorney in your particular state, get some specific legal advice, particularly if there's some kind of weird things going on, in a situation like that.
Great. So we're saying impersonating a police officer is legal for that's illegal for a regular person, isn't it?
Yeah, no,
Right.
In general, that's illegal. It's a crime, I think, a real crime, not an FDCPA crime. I'm just saying so the actual real crimes aside, I don't think it gives rise to an FDCPA claim. But there could be other criminal liability or issues there going on that may not directly impact the case, but have other impacts.
Like a process server can impersonate a pizza guy, right? I don't think there's anything illegal about that.
Yeah, that would be different than a cop for sure.
Right.
But
right.
To get you to open the door,
so
that kind of thing.
Yeah, so impersonating a police officer is illegal. Might not invalidate the entire case, right? Also, you still need to respond to the case, right? If you don't respond, you could still lose the lawsuit. If you really was impersonating a police officer, you might want to file a police report.
Yeah.
Against the process server. You probably have his names on your document.
Yeah, I mean, if it's legitimately wearing police uniform, badge, all that kind of stuff, that's a much bigger deal than, like you were saying, not them saying it's Domino's or whatever, and just to get you to open the door.
And it could happen, right? I mean, some of these process servers, they're just like a random person that's paid like $20 to deliver this lawsuit to you. And
yeah.
Some of them are more professional. Some of them are just kind of fooling around.
Yeah.
So yeah, you might want to look into filing a police report there. Glenise, can I be sued for a debt more than 10 years old? The last action on the account was 2012, and this is our last question. Looks like we're about half past the hour here. So, what's next if no movement has taken place on the case since I entered my objection and response? So she's wondering, what's next?
Well, you could do one of two things. You could file just a motion to dismiss for failure to prosecute. Most jurisdictions, there's some type of time limit that that the case needs to proceed to trial, or the court will dismiss on its own. So you could file a motion to dismiss for failure to prosecute. It's their case; they've got to push it to trial. If they don't, ask for it to be dismissed and be dismissed with prejudice. A lot of times the courts will dismiss it without prejudice, meaning that it could be refiled again. Or if you think that the statute of limitations has expired, you could file a motion to dismiss or a motion for summary judgment, just showing that, hey, that it's outside the limitations period, whatever that is in your state. Like in Arizona, it's 6 years. So if there's been no payments for 10 years, then yeah. It also depends too on what kind of account it is. If it's a credit card versus like an installment loan, like a, something where it's like a car loan or something like that, that can make an impact on the statute. Maybe something you want to talk to an attorney in your specific area if there's an issue that, if you want to really narrow that down, and then you could proceed with either dismissing for failure to prosecute or dismissing for the statute limitations issue.
Right. Okay. That sounds great, folks. Well, that is all the time that we have. We've had a lot of people here on the webinar. Hopefully we got to your question. We definitely didn't get to all the questions. Unfortunately, we do these things about once a week, so come back next time. Also, our wonderful assistant, Hannah, has been responding to folks in the chat, so hopefully she was able to get your question answered in the chat. You can also email us at support@solicit.com if you have any questions, or start a chat with us on our website. If you are wanting to respond to a lawsuit, make sure you go ahead and use this link here. This link will support John, and go ahead and use this link. Here it is in the chat. You can click that link and then use it to respond to your lawsuit, file an answer document, also get your case settled with Solo Settle. All right, folks, happy Pioneer Day. Take care.